Let's go, Yarela.
We're ready.
Welcome and good morning to everyone. We are really glad to have you at this Spain U.S. Chamber of Commerce webinar, where we are going to talk about strategic compliance insights, like a guide for U.S. companies. But before I introduce you our panelists for today and our experts, we would like just to remind you that we host at the Spain U.S. Chamber of Commerce many events during the year. Some of them are in-person events. Some others are webinars like this one. So please stay tuned in our website to check all the activities that we are hosting during the year. Our website is www.spainuschamber.com. Also, as we usually do, this webinar will be recorded and we will share the video with all the attendees, and it will be uploaded to our YouTube channel as well. So in case that you would like to share it with your colleagues, friends, and other people interested in learning about strategic compliance, you will be able to share those links with them and check the video whenever you have a moment. And the presentation will be also shared among the audience. So you will be able to get not only the things that we're going to talk about, but also, and most importantly, the contact information from the experts that today we'll have with us. And also, I remind everyone that we will save a few minutes after the presentation for Q&A. So if you have any question, any concern, any comment regarding the things that we're going to discuss this morning, please send those questions to us and we will take care of them at the end of the presentation. You don't need to wait until the end to send your questions. You can send your questions whenever you're ready. And to do that, you just need to click on the question tab that appears in the control panel that probably is in the right side of your screen. There's a tab that says questions or preguntas in case that you have set it in Spanish. Click there, write your questions, send it to us. We will gather all the questions and we'll address them at the end of the presentation. And now let's introduce you the experts that we invited today to talk about strategic compliance. So we have today on Thier, a boutique law firm that they've been with the Spain U.S. Chamber for many years, and they have a really unique view of doing businesses, not only in the United States, but also all around the world. For those of you that haven't heard about Ontier, they are a global firm with a strong focus on providing innovative and practical solutions to its clients, with offices in 11 countries between Europe, Latin America, and the United States. They offer a comprehensive range of legal services to businesses and individuals across a variety of sectors. So they do corporate law, but they do also many other things. And in fact, I have to say that they are one of the legal firms in the world that are at the forefront of blockchain technology and metaverse as well. That implies a little bit of technical issues here, and Ontier they are one of the law firms in the world that are experts in that, apart from business and corporate law. And today with us, we have Jason Rosen and Marta Corbi. Jason is an experienced corporate and litigation lawyer who joined the firm in 2022 after spending 10 years as a sole practitioner in his boutique business practice. Jason is counsel to various small to mid-sized companies in multiple industry classes and represents them in mergers and acquisitions, general corporate matters, and also in federal and state commercial litigation. Welcome, Jason. And we also have with us today Marta Corbi. Marta is a professional with experience in assisting companies in their internationalization process, with over 13 years of experience as a consultant in the field of international business. She has held the position of country manager for Ontier in the United States for the past decade. So welcome, Marta.
Thank you.
And now I leave the floor to Marta and Jason, and I'll see you later for the Q&A. But thank you so much, Jason and Marta, for being with us today.
Thank you.
Perfect. Thank you. Thank you very much, Juan Carlos, for the introduction and for letting us be here today talking about this important topic about compliance. We hear a lot about this, but unfortunately, like many companies, maybe they don't take it as like when they become international, when they go to another country, they sometimes forget it. It's not on their top priority list, but I think within the attendees that we have here today, it is very important to at least hear what Jason will explain in a little bit, the checklist and the different parts that you would have to be taken care of. And obviously here at Ontier, we would love to help you in anything that you might need. So here today, we are gonna explain what is compliance, why is it important. We're gonna talk about the Corporate Transparency Act, which I am sure that you've already heard about it, but it's very important because it came into effect this past January, and it applies for every company that is established here in the U.S. Then also a more general corporate compliance overview, and then we'll move on into anti-money laundering and the infamous ESG, or whatever name that we're going to use from now on. And then we'll just have the Q&A, and as Juan Carlos was mentioning, you can already start sending us the questions on the chat box that you have in your screen, and at the end we'll answer all your questions, and then we'll also be leaving you our contact information, and we'll be happy to schedule a one-on-one free meeting with any of you, and then see how can we help you. Just to, and even though like Juan Carlos says, so I'm going to be very brief, but for the ones of you that don't know who we are originally a law firm from Spain, but over like 12 years ago, we decided to go abroad, and nowadays we are in different countries in Latin America, in Europe, and in the US. We decided to establish our office in Miami, because obviously you very well know that is the gateway to the US, but as well to Latin America. And here we help a lot of diverse companies, but mostly the ones that they're starting their journey here in the US. And we help them with some things as easy as a company formation, but then we help them in their day-to-day, anything that they might need. One of those things, the compliance factor. And then, yeah, we have all these different offices in those different countries, and we all act as one. So even, for example, if you're a company from Spain and you rather pay your legal fees in Spain for your US services, we are able to do that. We are very flexible. We really want to work the best way for you. And in that sense, also, we work with fixed fees here in the US, which more and more other law firms are using it, but we started using it many years ago. We do a very flexible structure, the famous igualas in Spain. We do the monthly retainers in the US, basket of hours. At the end of the day, like whatever you feel comfortable with. And now let's move on to what really brought you here today, which is compliance. And I'm gonna turn the floor over to Jason so he can really explain to you today.
Thank you, Marta, and thank you, Juan Carlos, who I know is there, but you can't see him. But before we jump into talking about compliance, I kind of want to share a little bit about where I've come from and what I've seen in the compliance world since I started in my professional career. And really, in sum, what I've seen is that compliance has gone from a negative a negative focus to one that can be flipped on its head to be a more positive one. And in one of my many majors in college, I studied advertising, and I was always amazed at, I believe it was Schlitz beer that had an advertisement that talked about how their bottles were steamed cleaned. Well, every beer bottle back then, and maybe still today, was steam cleaned, but they decided to talk about it. And by doing that, their sales exploded. So, another example I saw was companies or hotels that say, well, we have clean sheets. Well, I hope every hotel has clean sheets, but putting it out there can give that trust to people. So similar is the world of compliance. So I started in the financial world prior to being a lawyer as a back office compliance officer for Fidelity Investments right out of college at 22 years old during the dot-com bust. So this was 2000, pre-September 11th. And I was literally in the back room, and it was kind of a culture of telling financial advisors, no, you can't do that. The person that you may have sat with, Mr. or Mrs. Financial Advisor, that sat with the clients, understood their needs, understood their risk tolerance, saw where the money was coming from, and really knew the customer, and was suggesting a certain investment, was shot down on many occasions because perhaps a piece of paper was filled out in a certain way. So I saw where compliance can become a negative component from the revenue driver, but at the same time was there to ensure a safe business operation. I moved from there to taxable bond trading, where obviously there was not much in the world of compliance that's relevant here. But then 5 years later, I went to financial advising, where I was on the opposite side of the spectrum as a financial advisor, which was then Bank of America Investment Services, now Bank of America Merrill Lynch. And I was now on the opposite side. I was the financial advisor, meeting with my clients, understanding their needs, stronger with knowledge than I was before, understanding financial products, and still having those issues with a compliance officer telling me no when the investment truly was proper. But that was the negative side of compliance. Fast forward to leaving the financial world on a Friday and starting law school on a Monday, working at the SEC as an intern, the Securities and Exchange Commission, while in law school, and leaving law school and joining my father's practice before being a solo practitioner. For 6 years, I worked on federal and state criminal matters. My father is a 50-year federal white-collar attorney who is still practicing today, and I had the pleasure of working with him and being a part of grand jury investigations, seeking documents and compliance program information, being a part of trials, federal trials dealing with money laundering, and working on what I believe is still today the appeal of the largest Foreign Corrupt Practices Act sentence ever handed down, which was, I believe, 15 years. So I got to see a wealth of knowledge throughout my career, and to hopefully share some of that with you today. So with all of that said, what is compliance? So next slide, please, Martha. According to the Cambridge Dictionary, compliance is defined as the act of obeying the law, a law or rule, especially one that controls a particular industry or a type of work. Another website, since books are now apparently sadly outdated, according to dictionary.com, the act of conforming, acquiescing, or yielding is how compliance is defined there. And under Merriam-Webster, it's the act or process of complying to a desire, a demand, a proposal, or a regimen or coercion. And if you take a step back and look at all of those definitions, what you see is putting your eyes down to the floor, no eye contact, hat in hand, and I am sorry, sir or madam, I will do as you tell me to follow the rules. And that is part of what compliance is, but that is not the spirit behind it. It is not exactly that. So if you could on the next slide, please. So tell me why compliance matters to my business. And we tried to put a Backstreet Boy logo. Apparently it's not in sync, as my wife tells me. It sings that song, but due to copyright issues where we have a nice black background. Why does compliance matter? Well, there are probably, no matter what business you're in, a specific set of laws or regulations that require it. Whether you're in the banking business, the energy business, even own a gas station, there is something out there that says this is how you need to conduct your business. from a, again, defensive position, a liability mitigation. As I mentioned, in the real world, I've seen and worked with companies who have been recipients of grand jury subpoenas. Something where when a company receives such a subpoena, which you always hope to God to never get, the first call is to the prosecutor handling that and saying, well, what is my client? Are they a witness? Meaning they just have information relevant to the investigation. Are they the target? Meaning, just like the name sounds, or is the government gunning to prosecute my client? Or are they a subject somewhere in between? And while that certainly category can change, the idea is that a good compliance program, and why it matters to your business, is that may be very important in how something like that gets handled. A good compliance program that's put into place, followed and maintained and audited and checked and revisited frequently can really assist a company should that ever happen. And it happens, and you may just hear about it on the news, but it's certainly something that does happen. And when you are dealing with a prosecutor, it certainly is a wonderful position to be in, to say, here's our compliance manual, here's how we handle things, and whatever problem that may be out there, this is not a company-rooted problem, and it's something that can certainly assist the business. Forgetting the government for 1 second and moving on to third parties, should a company be subject to a civil lawsuit, whether by a former employee, a shareholder, or some outside party, a compliance program would certainly matter to your company to show this is how business has been conducted, and it's been conducted properly. And forgetting showing somebody how it's been conducted, if you do have a properly working business, you mitigate that ability to even have a lawsuit. Now, we do live in the U.S., and this is a very litigious society. However, a good compliance program can certainly reduce the number of those lawsuits, and if one does come, you will be certainly prepared to handle that. And then third, where I've seen a huge change in compliance, and to my earlier marketing example of the steamed beer bottles, is that your business could be more attractive and therefore more profitable. So rather taking the mental status of compliance as this is something that's going to cost my business a ton of money, I'm going to have to pay for a manual, we're going to have to hire a chief compliance officer, and all it's going to do is hurt my revenue because compliance is going to tell my sales department no. Instead, having a good compliance program, as we're going to discuss, could actually be beneficial. On the corporate side of matters, we've worked with companies who have a very stringent process and will only work with other people in their supply chain who have a similar process. And whether we like it or not, one way or the other, we or our companies are in some part of a supply chain. And having that program, having those ideals, having that culture could make your company more attractive to others out there, and increase your revenue rather than thinking of compliance as just a negative cost. Next slide, please. So this is kind of the highlight, even though it's something that's relatively straightforward, but it's something that's new. It was signed into law in 2021, and it became effective as of January 1, 2024. So we're already about 50 days into it, and that's called the Corporate Transparency Act, or CTA for short. Next slide, please. So what is the purpose of the CTA? Well, like you see it on the screen in all caps, it's transparency. It's what's in the name. If you ever have formed a company before, and using the great state of Delaware as an example, to form a company, you really need a name that doesn't look similar to or doesn't match any existing name. You need a mailing address, you need a registered agent and an address for them to receive your service of process should you ever be sued. And you pay the fee. And lo and behold, you have yourself a corporation or a limited liability company. And that really doesn't provide the ability for the government to investigate any further or to have any knowledge of what is actually behind that name that's not similar to other names. And while this may be fine for any of us who are doing their business properly and who are out there in the world doing good things with our business, it's also a wonderful opportunity for bad actors to conceal ownership in a corporate structure. And that allows them to evade detection. But really, who cares? Well, it matters because by hiding ownership, it allows these bad actors to facilitate illicit activities such as money laundering, which we'll get into, terrorism financing, which due to the events in October 7th will certainly come to light more and more as we learn more. Proliferation financing, tax fraud, human and drug trafficking, counterfeiting, etc. And while a normal, or not normal, but while a simple LLC could simply be Frank and I have an LLC together, well, that's 50-50. And what's to know? What's the problem? That's just two of us. But what if our LLC is owned by 4 other LLCs and it is managed by 2 other LLCs, and each of those are owned by 5 different corporations? Well, you begin to see how this can trickle down into basically not knowing who really is there at the end of the day, who's controlling this, who's pulling the strings, and what exactly are they doing with those. So that is the purpose of this act. Next slide, please. So who does this matter to on the outside world other than the government? Who has to report? Well, on the right side of the screen, you'll see that there are exceptions for companies that don't have to report. And they don't have to report because typically they're already reporting somehow. So if many of you are banks or securities companies, you are already reporting, and you have been for quite some time. Who are the beneficial owners? Who are those? And we'll get into that. But who are those that own a certain percentage of the company? Who are those that can make large decisions on behalf of the company? So if your company finds itself on the right side of the screen, then this is not something that you need to comply with. However, this should be checked into just to be safe, and we'll get into why in a moment. On the left-hand side, you'll see who has to report, and the short answer is it's everybody else. Limited liability companies, corporations, partnerships that have registered with the state, limited liability partnerships, and any other similar entity that was created by the filing of some type of document with the Secretary of State of a respective state. And now, I'm speaking very broadly. Of course, there is more nuance to that. But if you fall on the left side somehow, it is certainly a good idea to speak with counsel to find out whether you are somebody that needs to report. Next slide, please. So that's great. You have an LLC or a corporation, you have to report. So what are we reporting? Well, the government wants to know, specifically, it's the Financial Crimes Enforcement Network, as short as FinCEN, that is a part of the U.S. Treasury. They want to know who are the beneficial owners of that company. And a beneficial owner is defined, again, this is the short definition, as those who directly or indirectly or through any contract exercise substantial control over an entity or control 25% or more of the ownership in a company. And if you look at that carefully, there's a lot in those few amount of words that are on the screen. So first, it's an individual. Second, it's directly, meaning I own in my name a certain percentage of the company, or I have a substantial control over that company in my name. Or perhaps I have that control indirectly. I have that control through a trust or through another company, such as the example I was giving earlier of an LLC being owned by an LLC, and perhaps that owning LLC is mine and I control that. Or there's a possibility that I could have a substantial ownership or 25% ownership through some type of contract, as I mentioned, like a trust agreement or a profit interest, or perhaps one day I will be an owner of this company, and it's a definite ownership. So there are many nuances here that you should probably work through with counsel should you find yourself in any one of these situations. And this could be, again, it's somebody that holds a certain percent of ownership, which may be straightforward, or one who exercises substantial control. Now, substantial control can be certainly something that's debatable, but according to FinCEN now, and again, this could change, as I'm not sure if many of you have seen, but our original article on the topic, and we'll get into that moment, mentioned an old guidance by FinCEN, and that has since changed. So this is brand new, and certainly things could change, but individuals that have substantial control are those like senior officers who are holding a position or exercising the authority of something like a president, a chief financial officer, general counsel, a CEO, or a chief operating officer. So these are people that can have a significant influence on a business, and not just somebody who is a manager. So you could find yourself as a lawyer for a company and fall under the definition of a beneficial owner. And again, this certainly gets to be more complex, but due to time limitations, we'll just leave it there. So Martha, next slide, please. So what needs to actually get reported? Well, this is a lot simpler once you figure out the mathematics of who actually has to report. So what needs to be reported is, once a beneficial owner is determined, it's their name, their date of birth, their address of the date of reporting, and some type of identifying number like a driver's license or passport number. And where does all of this information go? Because that's a topic that certainly is the next question. This information is meant to be kept in a database. It may be shared by FinCEN with other government agencies, state government agencies with court permission, as you see on the screen there on the slide, can receive the information. But it is intended that this is not to go out to the public, and this is meant, again, for investigative and intelligence purposes. Next slide, please. So what are the deadlines that are required here now that this is in effect? Well, if you're a company that's been in existence prior to the start of this year, so a company that was formed December 31st, 2023 and earlier, you have till the end of this year to report the beneficial owner information, so you have some time. If you are a new company that was formed January 1st or beyond, you have 90 days. And as I was mentioning earlier, when we originally put together an article for this, it was 30 days. That has since been changed to 90 days. And once we pass this year and FinCEN has a good grasp of how this all goes, the current plan is now that companies that are formed after January 1, 2025 will have 30 days. So that 90-day window will be shortened. Next slide, please. So why is it important to, as we talked about in the first definition of compliance, to say, yes, sir, or ma'am, I will comply, because you could be criminally and civilly liable if you don't here. So going to the bottom first, let's look at the penalties here. So on the civil side, if you violate what's written above, you can be subject to a $500 per day penalty if the violation continues or has not been remedied. On the criminal side, you can be fined not more than $10,000 and imprisoned for not more than 2 years or both. So you're thinking of or you're looking at a felony here because we're looking at a crime that's beyond 1 year. So you would have a felony on your record. You would lose many civil rights if you are at least a citizen here in the U.S. And typically, you're going to see an indictment, because I have not seen an indictment in my career that has only had one charge on it, and there will likely be others. So if you're not reporting, there is something beyond not reporting, and let's talk about why if you look above. So here is what happens, or what leads to that place of the penalties below. So it's unlawful to willfully provide or attempt to provide false or fraudulent beneficial information. So if you look at the first word of willfully, that means purposefully, meaning it wasn't an accident, but that you truly intended, or not truly intended, but intended that the government would have to prove to provide or attempt to provide fake or false information. And below that, there's a small typo at the end of that sentence, but it's also willfully fail to report, complete, or update your beneficial ownership information. Now, I wouldn't tread on the excuse of it was an accident or I forgot, because accident is not an excuse for a crime. It's not a defense. You can't drink a bottle of vodka, drive the wrong way on 95, and then say I didn't know, and that's your defense. So the statute as it shows a mental intent of willfulness, but still, again, something that can easily be avoided. Next slide, please. So we're just going to touch on lightly, because we don't have too much time, of general corporate compliance information, which is really just the day-to-day management of a company, and taking away the sexiness of grand jury subpoenas and criminal defense and all of that type of stuff. So next slide, please. So what we're seeing here is just the day-to-day examples of how a company can create a good culture within and to avoid a lot of problems that we see here on the dispute resolution side, and that what we try to remedy on the transactional side of our business, which is a company's culture really starts from the top down, and that's with the board of directors. So the rule making that's set into place, the officers that a company hires, the culture that trickles down, the programs that are adopted, that all starts with the board of directors. And the board of directors are charged with their own duties of having fiduciary duties and duties of care. And should those not be followed, the company could find itself in various forms of litigation, from various breaches of contract to possibly even a shareholder or a member of the company, depending on the type of structure, suing the company on behalf of the company or suing a director on behalf of the company for its mismanagement. Another is contract management. Again, this is not something that is as fun as anti-money laundering, but it's proper management of how a company is dealing with its contract. Are we complying? Are the representations and warranties, if any, still live and still accurate? Are we meeting all of our demands? Is the other side doing what they're supposed to do? Employment matters. How we're classifying folks. If a company is taking a pay equity analysis to make sure that all genders, that all classes of folks, that everybody is being treated in such a manner on the pay scale. And then permits and licenses. I can't tell you how often we can work with companies who said, you know, we've been doing business for all this time, but I think we lost our business license, or we have no idea what we need to do just to basically operate in the state of Florida or other states. So these are just simple day-to-day compliance matters, but if not followed, if left on the wayside and left aside because too many companies are focusing on the sales or revenue generation or future meetings, these little things can cause a good intention to explode. Next slide, please. So let's talk about the fun stuff, anti-money laundering. But before we talk about the anti side, let's talk about the money laundering. So what is money laundering? Money laundering is the use of illegal funds, or taking illegal funds and taking certain measures to make them clean, to bring them into the world and to distance them from their illicit source. And many of you have seen the fantastic show of Breaking Bad, and I hope I don't ruin. I would assume that all of you have seen it. But one example is the use of the A1A car wash that the White family purchases to launder the funds from Walter White's successful meth cooking business, where we see tons of money being brought in soda can containers, in soda crates, and the use of false invoices. So money laundering typically happens in 3 stages. You have the placement of the funds, where money is being taken from illegal sources and putting it into legitimate places like banks. And then you have the layering of mixing that in with those funds, and the integration, which is the final stage of now they are just part of the normal stream of commerce. So in that Walter White example, you had tons and millions of dollars of meth cooking money coming in. And we had a legitimate car wash business, and multiple false invoices were created to show that car washes were purchased but never actually purchased. And the cash that was brought into the business can now be integrated within, and it's now a legitimate fund that can be utilized and paid out to its owners. So how do we combat money laundering? Next slide, please. So to combat anti-money laundering, the responsibility, of course, and enforcement falls on the federal governments and the state governments, but this is where companies can really save themselves a lot of heartache, headache, and money by developing an anti-money laundering protocol. And while many here, I believe, could be in the banking sector or financial sector or money business, it's not necessarily only your business that is subject to this. There are matters, other businesses where this really matters, and we've seen it here in our day-to-day working with clients. So when we work with clients in assessing what their obligations are or what they should be doing, it's first understanding what regulatory framework you fall under. For those in the banking world, it could be the Bank Secrecy Act, it could be the Anti-Money Laundering Act that just recently passed with 2020, as well as the Patriot Act. So, but there are other risks that need to be understood in your business, and part of that is really getting to know, for us, getting to know who does what within a company, who the company is seeking to sell to, because ultimately there is a buyer, who the company is buying from, and understanding the whole mechanism of how the company works to understand how to best guide it in this process. So one of those steps is knowing your customer. What can you do as a business to understand who you are doing business with? For banks, it certainly is a very comprehensive, which is pretty much they have been doing the Corporate Transparency Act compliance for quite some time with their own customers, but is it getting to know who the ultimate beneficial owner is of the business, who you're doing business with, where are they getting their source of funds, what are they planning on doing with your product, etc. And then having that protocol in place, you can put in something like a customer identification program, some type of risk assessment where you can rate and see whether it's worth doing business with this person. Now, you may say, we have a customer and we know them very well. We know them personally. We have been doing business with them quite some time, and they're more trustworthy as compared to somebody that solicited us off the internet and we have no idea who they are, where their money's coming from, what they're actually doing with our product, or if they're going to sell us a product, where that product actually came from. And that allows us to put together a program from there. But having a program is just one part. There's also the monitoring of the program. So for example, transaction monitoring, which is very easy to talk about in the bank side, is to see, look at what type of deposits are going on, look at the movement of monies to see in one person's account whether there are certain transactions that are frequent, where something could look suspicious, but that is just what the customer is doing to do business, and it's very innocent. Should something fall under a regulatory framework or something that falls under your plan, you may need to report that to FinCEN, or at least higher up in the company, so it can be known that there is something that's being observed. And as I mentioned earlier, part of this that really matters is the culture that a company has. And if it is going to have a good compliance program, that comes from the top down. So you have a plan, a board of directors that desires to have a compliant company, and whatever compliant may mean, and to adopt a certain plan, to hire a compliance officer, whether to determine whether the compliance officer should be the general counsel and what the pros and cons of that are, especially if something does come up, or to eliminate, possibly not doing that, to eliminate certain biases, to be able to train management below the board to say, this is how you need to govern your employees and what to watch for. And then, of course, there's the employee training, which is very important, because those are your eyes and ears. The employees are the ones on the ground who are out there interacting with the outside world, and those are the ones who can spot the issues the best. And the rest of the list, as you see, is keeping to make sure that everything is kept in order, from the board meeting minutes of where things are adopted and how management shall be trained, et cetera, all the way down. So in the event something does come up, and forget something as dramatic as a grand jury subpoena, but let's say there are whispers of an employee paying a potential customer, an individual representative of a customer, for business. That's something that could put the company into some serious trouble, that could cause some serious reputation damage. And by the proper protocol of how to handle this, it allows that employee who noticed this to be able to report up the chain without fear of repercussion, to allow the company to conduct an investigation with outside counsel, and the ability to handle this and report to the authorities if necessary, rather than this not being noticed or a fear of reporting, and this just gets out of hand to the point where then that dramatic grand jury subpoena shows up at your door, or some news report comes out of allegations of bribery happening at your company, which will destroy the reputation and then probably lead to that grand jury investigation. So I know I'm speaking dramatically here, but these are just real world examples that we've seen. Next slide, please. So as I was mentioning earlier, my company is not a bank. My company is not a securities broker. What do I care? about compliance. And these are just kind of a list of stuff that we were mentioning earlier of things that could actually happen to a company. These are not made up things. These are not here to scare you, but these are just things that could that are very possible. And with a good compliance policy in place, with a good culture in place, these are some things that can certainly be avoided. Next slide, please. So what are some real world examples? Because war stories are always the more fun stories than being lectured to. Well, we've seen clients who have experienced bank account closures out of the blue, where they had suspicious activity happening in their account. And while they may have been conducting their business honorably, they may have been doing business with folks who are not so honorable. And the banks may know about that. And they may see the source of the funds. So a bank could look at the situation and say, you know, this is a company that's been our client for some time, but they're receiving significant wires and they're receiving significant payments, while maybe for the a legitimate sale, a legitimate service being performed, it's coming from an illegitimate place. So we're going to decide as an institution to not do business with those clients. The point of this example, and this also goes with the rejected wires of monies not coming in for sales that may have occurred for the same reasons. And why this is important is it allows the company, or having a good compliance program, allows the company to know who they're doing business with, to assess those risks. And if something were to come up with a bank, to be able to speak with the bank and work with the bank, or at least to find out, say, you know what, our compliance program was doing what it was supposed to do, perhaps it wasn't strong enough, and the bank identified some examples of bad actors, and that allows the company to immediately stop doing business with this customer or supplier and avoid some bigger issues. As I mentioned, I've been a part of multiple federal investigations on the defense side, thankfully, where we've worked with clients who are recipients of grand jury subpoenas, and it is an intensive project because it is for the federal government who's looking into this, it's obviously not a surprise. For the company, it certainly can come as a shock. And with good protocols in place that a company may have beyond compliance, including data, it requires counsel to meet with management, to meet with employees, to conduct a full line of investigation within the company to understand what may have led to this, and to have forensic experts go into the company's systems and pull all of the emails, all of the data that are responsive to these subpoenas or potentially responsive to these subpoenas. And require counsel to go through them to see if they are actually responsive, to see if there are any privileges or work product doctrines as to why these documents should not be provided, and to represent the company and best as possible to ensure that no charges are filed if they are a potential target or subject here. But we have seen that in various industries where these were typical business dealings that fell under some type of scrutiny. We had some examples of possible Foreign Corrupt Practices Act violations, where there were monies, businesses in the U.S. doing business with foreign countries where monies were paid to quote unquote grease the wheels. Where that maybe in perhaps that jurisdiction that is acceptable, but in the U.S. it's not. And especially under the FCPA, which if monies are paid to government agents, government intermediaries, that certainly creates a gigantic problem. And then on the positive side, on the supply chain, we've seen companies that have a very particular way of doing business, and they say we have a certain culture here where we follow, as we'll get into the next slide, of ESG, or we have a certain environmental component, a certain type of person who we're willing to do business with, and we want to vet them to make sure that what they are selling to us comes from a legitimate source. It is not from forced labor. It is not from a sanctioned country. And who we're selling to is a qualified customer, that it's somebody that we have done our diligence on and we know well. So this is what I was mentioning earlier of somebody, how it can actually benefit your business beyond the risk mitigation of what if these bad things happen to me. but from the positive on the offensive side to say, I want more business and I want to be able to put it out there to the world that we follow a certain protocol, and these are the matters, the practices we take to ensure that we are doing our business properly, and again, that could attract the right business. So next slide, please. So I'm going to go through this part relatively quick because we're running short on time. But this last part is environmental social governance, or ESG. And in the days of the country that we're in now, or the world that we're in, where things are very polarized, this has received some negative pushback because it is now deemed as a woke, quote unquote, woke compliance. And I was reading an article that mentioned somewhere around 2021, there were 150 something public companies that on their earnings calls were mentioning ESG or something similar to that, where in 2023, towards the end of 2023, only 9 companies mentioned the term ESG. But what we are seeing are companies may not be using this specific term, they are using other terms, and they are certainly following the ideals behind it, but the term has not fallen favorably in the polarized climate that we're in. Next slide, please. So it stands for, as you saw on the last slide, environmental social governance. Next slide, please. So why is this important? It's important because whether you believe it or not, the climate has changed, and whether you believe it or not, why it's changed, well, there are certain companies out there that are doing things to help mitigate any damages that further create this global warming that we're facing here. So you have companies that make it a priority in how they do business internally to say, we want to leave a minimal carbon footprint. We want to do the things that we can to conserve. We recycle everything that we can. And we want to make sure sometimes that everybody knows that, because that may be important to the consumers of who they're selling to, or the suppliers of who they're buying from. Human rights is another important matter. Of we're trying to stay away from forced labor, for example, involuntary servitude. And there was an article that recently got published by the Associated Press talking about that many of the products that all of us buy from stores that most of us buy from are carrying products that were made by a form of involuntary servitude by prisoners within the U.S. And it's actually completely legal under the 13th Amendment, which was created after the Civil War, or towards the end of the Civil War, was that there could be no slavery, no involuntary servitude, except for those convicted of crimes. So these are prisoners who are in the supply chain of manufacturing products that we probably all buy. And that could be something that's important to a company that says we make sure that our products are not part of that chain. And this goes again into morality and consumers. Next slide, please. So what are the common criticisms besides just this general wokeness that you can't force upon us your value type of environment? It's the cost. The cost of doing business could be more expensive by sourcing certain materials than those that are cheaper if they're made by people that are forced into working. The politics, as I just mentioned, and greenwashing, where it is becoming, because it is so popular to say we are a green company, or we are a company that deeply cares about the environment. Well, you can say all of those things, but if the type of business that you're doing is actually harmful to the environment, that's one way of greenwashing, is you're making yourself appear as a company more environmentally friendly than you actually are. Next slide, please. So where do we go from here? Because we talked about a lot of information in a very short time. The basic idea is, before you're figuring out how to take all of this and wrap your head around it, and what do I do to make myself compliant, I think the first thing to do is to really take a self-assessment, and not to sound too psychological here, but to assess what the company's purpose is, to assess what the goals are, to think about who their clients are, where they want to be, and to take all that and extrapolate what is the culture that we're trying to create. And many of these things may already be in process in your company, but they may not be in process in a writing. So it would be beneficial to understand how the company could be compliant if it's not with certain regulations. Take it a step down, how can it be compliant in its supply chain? And then to see where it wants to be in the moral structures of things, whether it wants to advertise it or not, whether it wants to on the naysayers be woke, and on the people that love the stuff to say that's wonderful. I'd love to buy products from a company that's socially or environmentally conscious. But the basic idea is to understand who you are selling to know if that's a legitimate source, to know who you're buying from and the different processes. There are a million ways to get there, but that is the basic premise. So I will leave it there, and I thank you for your time, and I welcome your questions.
Thank you, Jason. Thank you so much. I know that it's been a lot of things that we addressed today, but compliance, it's a big thing. It's not a simple thing. And I'm really happy to have Jason here and Marta. And thank you, Jason, for clarifying a lot of different things in this presentation. And as you said, this is the first step to learn about, well, not learn, you already know your company, each of you knows what your company is looking for, but to assess everything and think about it and then put it in writing or hire someone that could help you comply with the regulations that your business needs to comply with. So now we are going to open the Q&A. So we received several questions already, and I also remind everyone that if you like to ask something, just click on the questions tab that it's in the control panel, probably in the right side of your screen. Click there and write your question and send it to us, and we will address all the questions in a moment, starting right now. So let's see, first question that we have. What's the difference between an applicant and a beneficial owner?
Between an applicant and a beneficial owner. I'm not sure I understand the question completely of.
No worries, because if possible, if you could elaborate a little bit more the question. Arantxa is the one who asked this. If she could please send us a brief sentence, just clarifying a bit, and we will go over with this question in a moment. We have other questions that we're going to take care of. So meanwhile, get the explanation of this. I have one question for you. It's what happens when you first, Jason, mentioned who needs to report the beneficial owner. You had two different columns, the right side and the left side. What happens with nonprofit organizations? Are they required to share the beneficial owner? And if so, who would be a beneficial owner in this type of organizations? Like, for example, the Spain U.S. Chamber of Commerce. We are a corporation, nonprofit organization. We are non-for-profit. Who would be the beneficial owner in an organization like that?
That's actually a great question that I have not been encountered yet. So I would be happy to get back to you with that information.
Wonderful. We have the explanation, and Arantxa said when the previous question between the difference between the applicant and the beneficial owner. When you have to submit the beneficial ownership, they ask the information of the applicant and the beneficial owner. My question is if the applicant information and the beneficial owner can be different, and what are the differences?
Sure. So as defined there, yes. So we are performing the service. If that's exactly what she's saying, we are performing that service on behalf of our clients. So if we, as Antier, are the applicants, obviously, unless we own a piece of your company, we are different than the beneficial owner.
Okay, wonderful. Thank you so much. Next question. What has been the impact on financial institutions relating to Florida House Bill 3?
Related to which, I'm sorry?
what has been the impact on financial institutions relating to Florida House Bill number 3? I don't know if that rings a bell. For me, I don't really understand it, what the Florida House Bill 3 is, but just in case.
Um, I'm looking at it right now.
Probably saying anti-ESG bill.
Okay. So I don't know what the impact has been, but I believe that bill has to deal with and I have not dealt with it directly in our practice, but I believe that has to deal with the government doing business with the state of Florida government doing business with private companies, and it eliminates the requirement or this need to have some type of ESG presence in that. So I don't know the answer to the question, but I believe it's only related to government business with private parties.
Wonderful. Thank you so much. Another question, is it mandatory to have a regulatory framework, KYC, CIP, reporting suspicious activities, etc.?
Is it required?
Yeah, it is. If it's mandatory to have a regulatory framework for those things.
I would say it depends on your business. Certainly in the bank business or the broker-dealer securities business, and soon the investment advisory business may have beyond what is already being reported, especially with their transparency. But no, it's not required in every business. It really depends on what your particular business is. And one of the examples I was giving was a business that has nothing to do with the financial sector, has nothing to do with banking, and they were subject to certain issues of knowing their customer and exactly what you just mentioned, something that they had never thought of, and it had a significant impact on how they did business.
Okay, wonderful. Thank you, Jason.
Sure.
Another question. We are a small company, just 5 employees, and it seems to be an endless need for business to be compliant. How can a small company like us manage all of it?
That's the struggle, right? It's everybody wants more money and everybody wants another piece of your time. I would say that depending on the business, it would probably be worthwhile, of course, to meet with somebody like myself, who handles these type of matters, to understand the business. Many of the litigation matters that we see for getting this anti-money laundering stuff, many of the basic litigation matters we see here are companies that don't have proper governance in place internally, forgetting how they deal with the outside world. So we see many cases where LLCs exist without an operating agreement, and there are disputes of who has ownership, who has control, who can do what. So that's just one basic form of compliance that's not as far-reaching as the anti-money laundering. When you get into discussions with counsel about this kind of stuff, that's where it can be understood to see what is really needed. Perhaps it is a short manual to say, and again, all manuals are not the same. All ways of doing business are not the same. So, for example, we worked with a company that did business and it was strictly within the United States. So it was mentioned about the Foreign Corrupt Practices Act. Don't bribe foreign officials. I mean, it's kind of a basic thing. Don't do that. But it was in there, but it really wasn't a big discussion because really the matter was who were they getting their supplies from? Who were they selling to? And it really just, again, it just depends on the focus of the business. But what I would really harp on is internal governance is very important. The last thing you want is some nasty fight internally within the company, understanding who you have contracted with and what your obligations are. That's just basic compliance in itself.
Thank you so much. Another question. Do you need a compliance officer for every company?
Again, the typical lawyer answer, it depends. Would it be beneficial depending on the business? Sure. But again, depends on what the business is doing. If it's a frozen lemonade stand, probably not. But if it's something where you have a sales force, you have, let me give you an example. I worked with a company, it was an international company, and there were concerns that somebody within the company was paying a private company for business. And that caused a major problem because there was nothing in place to deal with that. And this person that was suspected was very high up within the company. So that caused even more problems. So to have a compliance person, sure, that would be wonderful. But if there was something where there could be a plan in place for the board to follow, it allows for mechanisms to be followed rather than personal feelings or concerns. But if a compliance person, a chief compliance officer is too expensive, you can always have outside counsel or outside audits done to make sure the company is following the plan and to assist, but not necessarily be a chief compliance person.
Thank you so much.
One thing, if I may just add on to that.
Sure.
Companies can also, because look, you can't just add another couple $100,000 to pay a new employee. So one way to do it is to assign in a 5-person company a person with the duty of you are also going to be the compliance person in addition to your job. It's not the perfect solution, but it's a way to at least start the process.
So that's a good way to start if there are small companies and you cannot afford someone else in addition. Thank you. Next question. Can you give us an example of consequences of not having anti-money laundering policy in place?
Sure. So, well, it may on the day-to-day matter. Sure, it will show you how you're doing business and whether you're following a proper plan. So if you don't have something like that in place, it's more of a gut feeling, or you're dealing with what information is given to you without a proper way to say, this is who this customer is and we know them well, this is who our supplier is and we understand where the products are coming from. Having that policy, you can certainly run your business without one, but it certainly is a way to allow a feeling-free, emotion-free, or bottom line free way of looking at conducting business.
Okay, wonderful. Thank you. Next question that we have, it's, I am a corporate officer. Does that mean that my information must be reported to be compliant with the CTA?
It's a good question, and again, it depends on what type of corporate officer they are. Right now, FinCEN has certain guidance of certain titles that need to be reported, as we mentioned, and then there are others where it depends on what their actions actually are. So could you be a vice president and not have to report because of your title? Perhaps, but maybe the work that you actually do may cause you, and the control that you actually have may cause you to be somebody that has to report. So it's one of those things where it's a case-by-case basis and should really be discussed with counsel.
Thank you. Next question. Where should be sent the beneficial owner's information and how? Email, e-form, mail?
So if you're using counsel or a third party to file for you, there would actually be some type of arrangement, obviously, to get that information. If you're reporting directly to FinCEN on your own, it's through the FinCEN website that everything gets uploaded. And there is no cost to FinCEN's website.
Thank you. Can you provide the website, if you know it, so that everybody here in the webinar could get
Sure.
the website right?
It is it's https://fincen.gov/BOI, and that's where it provides you links to prepare and file your filings, and also there are some frequently asked questions. Again, for a small company that has its owners in place, this is not such a large project. For those that have multiple owners, multiple different positions, or certainly LLCs or companies owned by other ones, it can become a harrowing task and one that you don't want to do incorrectly.
Wonderful. Next question. My company is owned by one or few people. Does compliance really matter if we all get along?
Yes, because you do until you don't. And I hate to sound like a pessimist, because there are plenty. There are plenty of companies that have existed for a long time and work really well and always have. But as a realist, there's too many times that we see problems. And for the minimal cost of having an attorney provide, I say minimal cost because it's all relative, but the minimal cost of putting together the proper internal documents of how a company's operated and how it conducts business with the outside world could be monumental in what the savings could be should something go awry, whatever that may be.
Thank you.
Sure.
Next question. Does the compliance regulation depends from state to state? Is it more stringent to comply in California than Florida, for example?
So the laws that we mentioned were federal, and I know we didn't get deep into the laws, but they're federal laws. Each state has their own laws and regulations as well. So again, depending on the business, where a business is registered and where it does business, both, even if it is a Florida company that's doing business in California, where it has an office, or may just sell to customers in California, may be relevant. It's a little bit difficult question to answer without knowing exactly what the business is, and to know a little bit more whether Florida and California are stricter, which is stricter. But I do know that California has more stringent consumer-friendly matters as compared to Florida, which is very corporate-friendly.
Thanks so much. So let me see. We have no more questions at this time. We have time for one more question if someone would like to send the last question. Meanwhile, I remind everyone that this webinar is being recorded, and we will share with all the attendees the link to the video and also the presentation, and of course, the contact information from Marta and Jason that you also can see it in the screen at this time. But in case that you would like to contact them directly for more details about what we addressed this morning, you have their email information and their phone number as well. So no further questions, so let's leave it as it is. Thank you so much, Jason. Thank you, Marta. Thank you, Montier, for being with us today. It's been a great topic. We learned a lot of different things, so don't be afraid. If you are in a company, mid-size or small company, don't be afraid. There are people that can help us to comply with all the regulations. Montier can help us and can help us navigate the difficulties of the regulations. But we can go through there and focus on selling more products and services and grow our business, which is the main reason why the companies are born. So let's keep the good work. And again, thank you everyone for joining us this morning. We hope to see you in the next event or webinar with the Spain U.S. Chamber of Commerce. Again, thank Jason and Marta for sharing this morning with us.
Thank you.
Thank you, Juan Carlos. Thank you, everyone, for your time.
Have a great day. Goodbye.